that a confiscation proceeding has been initiated by the collector.
But confiscation has not been done. No?
My lords, once the confiscation proceeding is initiated, every truck or rice, my lords, moving from one place to another can't be seized by the authorities. Only on the suspicion, then there can't be, my lords, any business. My lords, in this writ application, this petitioner is the owner of a public area truck, and truck was loaded with rice, and only on the suspicion that it appears to be a government subsidized rice.
So you have not asked for release of that truck under 451, 457?
The problem, my lord, is that a confiscation proceeding has been initiated by the collector.
But confiscation has not been done. No?
My lords, once the confiscation proceeding is initiated, then the jurisdiction of the criminal court is ousted. No application can be entertained by the criminal court in a case where a confiscation proceeding is initiated. The jurisdiction of the courts other than the High Court is...
When was the confiscation proceeding?
My lords, that, my lord, the seizure in the present case, my lord, is 31st of July 22.
Yes.
Then the learned collector has initiated a confiscation proceeding for which I have received a notice. And thereafter I am filing this writ application before my lords that the seizure and initiation of the confiscation proceeding itself is illegal, because according to the prevailing law, there is no control on food grains. The control is on the government rice and wheat which is being sold by the PDS dealers. Every truck or rice, my lords, moving from one place to another can't be seized by the authorities. Only on the suspicion, then there can't be, my lords, any business. Therefore, let my learned friends, my lords, have a short instruction, a short period. What he wants to say, I will furnish my security.
The seizure is on the basis of an FIR.
Yes. FIR, lecture 1.
Have you sought for quashing of this FIR?
No.
The option is that unless this FIR is quashed, if you say that you were not possessing, you were not carrying rice relating to, the secured PDS rice or anything of that kind, and without any reason the truck has been seized and the material has been seized, then you must question the FIR.
But question is,
this court is not going to give a finding.
But we are not asking for. From the perusal of the materials available on the record, and recently also in a similar type of case, my lords have interfered.
From the perusal of the material,
my lords,
if this court reaches to a conclusion that this rice does not belong to the government or its authorities,
yes,
then only, na? So, but that finding can be given in writ petition. That's
the latest
issue is whether we can entertain.
Recently, almost in an identical situation, my lords have held, my lords. Because, my lords, the confiscation proceeding is a separate proceeding from the criminal case.
Yes.
All these questions, my lords, were raised on behalf of the state, that there is a restriction, then the power of the High Court was also considered, my lords, that whether under these provisions this court can interfere or not, my lord. Keeping the truck under seizure, my lord, will not be of any useful purpose, my lord.
You are right, but if the confiscation proceedings have already been initiated relating to the truck, it cannot be handed over to you. Suppose if its ultimately confiscation is allowed.
Then, my lords, it can be taken back from the bond will be there, my lords. The rice was...
Then for that if that would have been allowed, then 457 proceedings can be conducted.
My lords, actually power for release is vested in the collector also. But problem is that the collectors are not entertaining any application, because if an application is filed before the collector, it will not be heard for a year. The power is given that once a confiscation proceeding is initiated by the collector can pass orders, and my lords have ordered in some application that an application is filed before the collector, then collector will consider the release of the truck. The Supreme Court has
Moved any application?
but unless we are here for holding that the initiation or the seizure, very seizure is
The
illegal.
council, if that facts are there before us, then perhaps we may pass some orders. But if you have never moved any application before the
Then,
collector
my
release,
lords, one indulgence can be done, my lords. Liberty be given to the petitioner to file an application before the collector, and collector should decide my application for release of truck within a time fixed by my lords.
where is it, that provision under 60?
Yes, my lords.
Please show us that.
My lords, section 6, section 6, my lords, capital A,
Of what act?
essential commodity.
Where?
Section 6, capital A, subsection 6. It's not a bar, my lords, under the law. Only the power of the criminal court has been vested in the collector, provided an offence under the Essential Commodities Act is made out. But in any case, my lords, either case is made out or not, he has a power to release. It's not a bar under the law.
Where is that power which you?
Notwithstanding anything to the contrary, my lords, subsection 6, my lords. In the code of criminal, when collector or the appellate authority is seized with the matter under this section, no court shall entertain any application in respect of essential commodities, any package covering etc., any animal, vehicle or other conveyance used in carrying such commodities as far as distribution and is concerned, and the jurisdiction of the collector or the appellate authority with regard to disposal of shall be exclusive. Therefore, the collector will have the power, but the problem, my lord, the application filed will not be heard for years. The truck will become, my lord,
How will we presume that? That it is not, that's why I said, those facts are not there before us, that he is not hearing for
My
years.
lords, I am here before my lords.
You have come after more than 1.5 years.
Or what I submit is.
See, you have not approached the collector for 1.5 years.
Yes, my lord.
You
Not
have
for
come
1
to
year.
this court.
It's around 7-8 months, my lords, but I am
July 22,
22, my lords.
we are in 23.
23 March, my lords.
Almost.
Yes.
But
But what I submit is, my lords, we are here
had you
for,
moved an application there, perhaps we might have passed an order.
my lords, I will withdraw my writ application. My lord may
All
indicate
right.
in the order that I can move an
That it
application
counts
before
for-
the collector.
That it counts for the petitioner submits. That the petitioner's truck has been seized on wrongful premises, and the goods which the truck was carrying do not fall within the ambit of EC Act.
Yes, very good.
Letter counsel submits that the confiscation proceedings have been initiated by the collector.
Yes,
Resultantly, he is prevented from moving an application under section 457 CRPC in view of the specific bar contained under section 6 capital A of the EC Act 1955. However, learned counsel prays to withdraw this present petition with liberty to move appropriate application before the collector,
Collector Madhepura, my lords. Collector Madhepura.
but collector for the purpose of release of his vehicle, which is lying with the authorities since July 22. Para. Section 6A subclause 6 provides as under. Thus, this court is satisfied that the collector has the power to pass interim orders release for disposal of the goods seized, which includes the vehicle. In view thereof, the petitioner is allowed to move appropriate application before the concerned collector, and if such an application is moved, the same shall be disposed of positively within period of 15 days
All right.
thereto. If the said application is not decided within 15 days, the concerned officer would be liable for contempt proceedings. With the aforesaid directions, the writ petition is disposed of.
One line, collector Madhepura, my lords, unless,
Collector Madhepura.
and arising out of PS case number, otherwise, my lord, he will
Don't
not,
make it as a
no, he
clerical.
will not understand in
When the
this
writ petition is mentioned, that is all.
case.
Please, sir, you are a senior counsel. Don't ask the High Court to become a,
Only for the purpose so
no,
that the
no,
collector
what-
may know in which.
show your writ petition if
Yes.
you have to show that.